You're watching 13 WMAZ Law Call, sponsored by Macon Law Firm, Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight we are dealing with debt. Woo, everybody's been there at some point or another, but some people have some really serious decisions to make. So tonight we're going to get right into it. We have two great attorneys with us to help answer some of your email questions. First, from the law firm of Reynolds, Horn, and Savant, we've got Marty Sin. How you doing, Marty?
I'm good, Morgan. How are you?
I'm feeling real good. It's always good to see you.
As you, yeah.
Yes, indeed. And who do we have with us to help answer some of these questions tonight?
Well, tonight we've got Alex Sanders. He's a bankruptcy attorney, and we'd like to have some of the best attorneys on the show here in their fields, and we think Alex is one of them. In fact, Alex and I go way back. We went to law school and graduated law school together. We both practiced in and around the Macon area since that time, kept in touch, and he's kind of a go-to for bankruptcy questions. Our firm, we don't do bankruptcy, but we have a lot of clients who have those issues that may come up during litigation or while there's a claim pending. And we often go to Alex and refer our clients over to him for that knowledge. But Alex is going to help us tonight and help us answer a lot of these questions.
Well, all right. Hey, Alex, it's good to see you again.
Morgan, the pleasure's all over here. I think this is probably my 8th time on this show, and I'm not sure why y'all keep asking me back, but I really appreciate it. And Marty, great to see you, bud. Marty and I do go way back, Mercer Law School. We had some good times. As a matter of fact, Marty and I were on the 2005 or 6 Mercer intramural softball championship team. I had to throw that out there before we started. I know that's not why we're here tonight, so I think some people have some questions for us. So.
Oh, yes, and I don't know if they'll be softball related. You never know.
Probably not, but
you never know. You never know. All right, well, let's get into our questions tonight. We do have a serious topic we're dealing with tonight, dealing with debt. And our first question comes to us from Brad. And Brad's question simply says, I haven't worked in 6 months, and I'm way behind in my mortgage payments. I have a mortgage and a second mortgage line of credit on my home. I have no savings or other assets of value. So which would be the best route for me to go, either Chapter 7 or Chapter 13? So Alex, what say you to Brad's concerns?
Well, first off, thanks for the question, Brad. And it's a good one because it's a very common problem right now with the pandemic, the COVID-19. A lot of people either lost their jobs for a period or had their hours cut, a lot of things. And if you don't have your normal income, it's hard to keep up with your mortgage payment. In this situation, if you want to keep your house, you're going to have to file a Chapter 13. Chapter 13 is basically for a wage earner that has a steady source of income, may have fallen behind, gives you the right to catch up your payments while you're concurrently making your regular mortgage payment. Now, sometimes it just depends if it's worth doing based on the value of the house and if there's any equity or not. I mean, a lot of times it looks like you have 2 mortgages. A lot of times the amount of debt is a lot more than the actual value of the house, and it may not be worth keeping. And the avenue for that would probably be Chapter 7. You could surrender the house and all the debt that came with it. But this is kind of like I always like to say, fact specific. So you probably need to come talk to me and we could dig into it a little more, but I appreciate the question.
And you know what, that's very important. I think, anyone who has a question, if they can get in to see your personal attorney, that's always a good idea. And having said that, Marty, I mean, are the courts open yet? Can people go to court, or can they even come into your office to visit you?
They definitely can come into our office and visit us, and we can definitely still file pleadings with the courts. We're moving depositions along. There's still a stay on jury trials, but we're hoping that's going to open back up. But we are starting to see some of these problems. And Brad's question actually kind of segs into a good question that, Alex could address, that we have a lot of clients ask us or the difference between a 7 and a 13 and how that might affect claim they have pending or a possible case, and Alice, you could probably touch on that some.
I certainly can. I think this question gets asked every show I appear on, and it's a hard one because I could literally talk about it for 5 hours. But the main difference in the Chapter 13 and Chapter 7, Chapter 13, you have a steady wage. You may make too much to file a Chapter 7, and there's a median income that's set by the census. You'd have to look into with your attorney. But Chapter 13, you're usually behind on something, whether it be a mortgage, a car payment, tax debt, and you need to catch up on it, through a 3 to 5 year plan. So of course it lasts a little bit longer. Chapter 7 is more of a straight bankruptcy. You basically file that, it's quicker, 6 months. And if you have no equity, you don't own any property worth over a certain level, you can just get your debt discharged. Also, like we were talking about with Brad, if you have a house that's just basically underwater, it's a good opportunity to kind of rid yourself of that. You surrender the house to the mortgage company and that debt gets discharged. But I call the Chapter 7 mainly the fresh start bankruptcy. But anyway, that's a good question, Marty. And of course, I'm going to say it probably 100 more times, but it's fact specific. So give me a call and we'll get into it more, if someone has an issue like that. Thanks.
Okay. All right. Well, let's move on to our next question. It's from Marla. And this really is kind of a courtesy issue that she has. And her question goes a little something like this. I have a discharge Chapter 7, yet creditors continue to send collection letters after I have politely asked them to update their files and stop contacting me. I filed pro se, so there is not an attorney to ask. I will send another cease and desist letter to them, but is there anything else that can be done? And that's a fair question. Nobody likes to be bugged over and over and over again, but sometimes it happens with creditors. What can she do?
Well, there is something she can do. I mean, pro se cases are difficult because bankruptcy law is just very complicated, convoluted. There are a lot of missteps you can take that can get you into trouble. In this situation, she would have had to list the debt. If you don't list the debt, you're not eligible for discharge. You don't get the protection of the automatic stay, which precludes them from calling you. In this situation, I mean, you have the same rights as someone that filed with an attorney, but they don't. It probably would be a good idea to hire an attorney that could reopen the case and put some real pressure on them, because they are violating the automatic stay, but you just probably don't know how to present that to them. And so I think it would be worth it, especially depending on the amount of debt, to talk to someone, see how much it would cost. I'm not sure it would cost too much to reopen the case and get it fixed. And that way they won't be hassling you anymore. But
okay.
Do that and appreciate it.
All right. Alex Sanders and Marty Sen are our attorneys tonight. I'm Morgan Dukes. You're watching Law Call, and we'll be right back with more of your questions.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, and with us tonight, we have two great attorneys dealing with debt. That's what we're dealing with. From the law firm of Reynolds, Horn, and Savannah, we have Marty Sin. And also we've got Alex Sanders, who is a bankruptcy attorney. And this is what he does all the time. So he definitely has some good bankruptcy answers for you. But Marty, I want to ask you a question. What happens if you are dealing with a personal injury case and the person that your client feels that they need to, file for bankruptcy, or they just don't have the finances to complete their case? What should they do?
Yeah, and that's an important question, and that's something we run into, somewhat often, because litigation, the type of litigation we do, does stretch out over the course of years, and sometimes clients find themselves in situations where they're having issues with debt or with money, and if we're about to, come to a resolution on a case, or if we have active litigation, there are consequences, or there are things to consider if a client does want to file bankruptcy, because if you go into bankruptcy, then the bankruptcy estate, the trustees can potentially have a claim to a portion of your settlement. That's when we would probably get someone like Alex and Bob to try to help the client maintain as much of that settlement as you can. And kind of like Alex touched on it earlier, sevens and 13s have different consequences when you're talking about a client who has active litigation or potential claim. So it is something that's important, and a person should talk to either their personal injury attorney or a bankruptcy attorney before they file suit if they have an active case, because it could have consequences and you could lose a portion of that settlement.
Okay. All right. Well, gentlemen, let's get back to more emails, because Richard has one and it's kind of interesting. It involves being a veteran. His question goes a little something like this. I receive Navy retirement and VA benefits. My wife has cancer. I quit a great job to take care of her. I cannot pay the $30,000 in credit card debt now. The house has no equity. Our car will be paid off in February, and our adult son with us has autism and lupus. He lives with us and we take care of him. Wow. I saw a lawyer and he said that we could file or not. He said that we should be able to protect our military retirement and disability. I don't really have anyone to get advice from. Please help. Now, Alex, this sounds like something you can definitely help Richard with.
I certainly think I can. First
Okay.
off, Richard, I appreciate your service, Navy retirement and VA disability. You served in the armed forces. And I'm sorry about what you're going through right now, and you certainly deserve a break. And actually, a law was passed in August of 2019. It's called the Haven Act, and it actually it benefits veterans. Before that time period, your VA disability would count against you on the means test, which basically says how much you have to pay to the unsecured creditors. Since the Haven Act was passed, that VA disability does not count against you. In other words, the amount you're having to pay to unsecured creditors, and in general you're having to pay in, is a lot less, and that's a well-deserved benefit that our veterans deserve, and folks that are getting VA benefits. But you certainly have a lot on your plate. I would love to help you, and give me a call, and hopefully we can get you out of this situation. But it is one I do think we could help you. But thank you very much.
Okay, all the best to you, Richard. All the best. All right, let's move on to Miss K. She has a question involving her father. She says, my dad co-signed a personal loan for me last year. I have too much unsecured debt and I'm looking into bankruptcy. I don't want to discharge the loan or even let my dad know about the bankruptcy. Is that possible? Can I keep the loan and keep making payments without it being affected by a filing? So what should Kay do in this situation, gentlemen?
Well, unfortunately, this happens sometimes. You side the loan, and stuff happens in life. You sincerely meant to pay it back, but you couldn't. As far as not letting him know about it, I don't think that's a good idea. I think you need to be upfront with them. But even if you didn't want to tell him, you have to disclose it. It's part of the bankruptcy code. There's actually in the schedules, Schedule H, you have to disclose any co-debtors you have. And if you think about it, well, if they're in a debt and you're, planning on discharging it, they certainly have the right to get served and know what's going on. But if he understands that, yes, you can continue paying it to protect your dad, and he knows that, and you're up front with him, it won't affect him at all as long as it gets paid. So I just think you need to be up front because he would know anyway, and it's probably better in your situation. So hopefully it works out. And if you need anything, give me a call. Thanks.
Okay. All right, gentlemen. Well, let's see. We have time for one more. Maybe this has a quick answer. It's from Nelson. I'm considering filing Chapter 7. I have $80,000 in credit card debt and a $730 car payment that has 22 payments remaining. The car is a 2016 and it was in really good shape until I had a wreck. I need a car ASAP. My question is, can I finance a car before filing Chapter 7 bankruptcy? I need a car for work and I can't work until I receive a discharge.
Okay, well, I think he can't wait for a
Oh,
discharge.
he can't wait.
Yeah, but that, no, that's fine. It takes, when you file, it takes several months, depending, to get your discharge in a Chapter 7. But I would say, Nelson, you're a perfect candidate for a Chapter 7. You don't want a car that's that expensive, that's wrecked, that's total. That's no good. And $80,000 worth of credit card debt is going to hold you down too. You can buy a car before you file. Yes, if it gets financed and there's no equity in it, well, the trustee in your Chapter 7 case is going to have no interest. You can reaffirm it. I mean, this isn't fraudulent. The car doesn't work. I mean, so you do have the right to file bankruptcy, surrender that to the creditor, and buy another car. But you can also, people think that you can't borrow any money, buy anything after filing bankruptcy. It's just not true. I've had clients, and there's some lenders that specialize in helping people with bankruptcy that I have their information if you need it. But if you wait for the discharge, it actually, you're a less risk to a lender because you're not eligible for that discharge for another 8 years. So they know you're basically going to have to pay it back. But you will be able to purchase a car before or after. It'll probably be easier before. And but the main thing is getting all that, I like to call it bad debt, off your plate and get it discharged. But thanks for the question.
All right. All the best to you, Nelson. Now, Marty, I want to ask you this question. Once a client receives their settlement, how is it then distributed? How does that happen?
Well, if it's just a regular situation where there's no bankruptcy issue, then, we would just distribute it according to the terms of the settlement and how the different people have to be paid out. If the client is actually in a Chapter 7 or Chapter 13, you have to get that approved. The trustee actually has to approve the settlement. Most often they will do that. They have to do their due diligence to make sure it's a reasonable settlement and there's not been anything really left on the table. But then they will get usually a portion of that. That's when somebody like Alex would be really helpful in trying to help the client maintain or hold on to as much of that settlement as he could. But we could not distribute that until it got approved by the bankruptcy trustee. But it doesn't necessarily have to go through the trustee. We just have to get that approval. We have to make sure we can keep for the client what we can keep. But that is something we have to take into consideration.
Okay. Marty Sin and Alex Sanders are our attorneys for tonight. We're dealing with debt. I'm going to take a quick break and then we'll be back with more of your questions right here on Law Call. If you have any questions for Alex Sanders, you can find him at Kelly, Levitt, Blakely, and Sanders. Their phone number is 478-841-9467, or you can find them on the web at www.bankruptcyga.com. And of course, if you have questions for Marty Sin, you can reach him here at Reynolds, Horn, and Servant, 478-405-0300, or on the web at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds, Horn, and Servant on Facebook. Both of these attorneys are right here in the Macon area. So let's get back to one more question. We have time for Michael's email, and his email asks this question. I qualify for Chapter 7 bankruptcy, but I want to know what will happen to my 1/9 interest in inherited land from my grandmother. May she rest in peace. It's 85 acres. Wow. So what should Michael do? Alex, what's your best advice there?
Well, I don't think it's going to be a problem here. I mean, 1/9 interest is a small amount. Now, if this property was worth a substantial amount and, gosh, it would have to be a lot in 1/9. They'll say $1 million, you'd have to look into it. I mean, they could potentially sell it and either offer for the family members to buy off the portion that you own or, just pay them off. But generally, a 1/9 is such a small. I mean, you have to account for it, but your only ownership interest is in that 1/9. Generally, you can exempt that interest. And another thing, if there's a mortgage on it, there's even less likely chance. But if it was a half interest, obviously it could be an issue. I think 1/9 he'll probably be fine. If you come in, we can look up the value and all that, and make extra sure before we file the case. But I appreciate you sending in the email, Michael.
All right. Marty, any closing thoughts on tonight's topic?
Yeah, that last question reminded me of old property law exam times.
It sure did. It's kind of difficult, to be honest with you, just like it was back in law school.
Sure.
I've done real estate law, but it's not my specialty. But, it was a great question.
I was glad you had done that class.
I know, yeah. Bringing back scary memories now.
Well, at the end of the day, we can always take it to the old softball diamond, right?
That's right. We may go throw we're going to go throw the ball for old time's sake, probably after this taping.
Okay. All right. Well, listen, if you have further questions for Alex Sanders, you can reach him at 478-841-9467. And of course, Marty Sin can be reached at Reynolds, Horn, and Servant, 478-405-0300. Gentlemen, it has been good to have you both here. And are there any closing thoughts you might want to say about bankruptcy?
I just want to say, a lot of people get kind of upset and worried, and they have anxiety over it. And I'd like to say there are a lot of people that have the same issues. It's very common. Call someone. It's probably not as bad as you think it is, and we could probably help you out. But just take a deep breath and give us a call.
It's always worth calling.
What was that, Marty?
It's always worth a call.
Yeah, because you just.
Consultation. I mean, you really have nothing to lose. So.
I like that. And both of you gentlemen offer free consultations. Am I correct?
That's right.
Yes.
All right. Well, it's hard to beat free, isn't it?
It is. It's rare, but it is hard to beat it.
Okay. Well, listen, until we get together next time, I wish you both well. And I don't know, will the courts be opening anytime soon? Is there a short answer to that?
We hope so. We hear they may be, but there's no final word on that yet.
Oh, okay. Okay, then. Well, we'll have to keep our fingers crossed on that notion. But Alex, we keep bringing you back because you have all the answers. You're very good at what you do.
I really appreciate it, and I hope everybody has a good evening.
All right. And I like to wish the same for both of you. Okay, Marty, Alex, until next time, have yourself a good evening. I'm Morgan Dukes. Good night, everybody.
Good night.